What are the key estate planning documents every senior should have in place? Can a trust protect your assets? And when do you need one? How can you or your parents plan ahead for a future long-term care need? I'm Ethan Huizenga, attorney and owner of the Huizenga Law Firm PC, and this is the Siouxland Senior Planning Radio Show. Since I'm a lawyer, we've got to start by getting the fine print out of the way. Since legal advice is extremely personal, you shouldn't take anything said on this program as legal advice. After all, I haven't met you, and I don't know anything about you, your health, your family, your finances, your fears, or, most importantly, your hopes and dreams. Instead, my hope is that what you hear on this program will be educational and thought-provoking. Iowa's making national headlines again, and it's not just because of Caitlin Clark and the Lady Hawkeyes. Last month, Iowa made national news for its collection efforts against incapacitated seniors and their families through a program called Estate Recovery. Today we're going to do something a little different, and I just want to chat with you for a while about what is estate recovery. We'll talk about what's included in an estate for estate recovery purposes, and look at who's subject to estate recovery and where there might be the opportunity for some waivers. So the first question is, what is estate recovery? Estate recovery is tied to the Medicaid program for seniors. So primarily, it applies to people who are over the age of 55, but it doesn't only apply to them. It applies to people who are in a nursing facility or a long-term care facility. It's there to make sure that the state recovers the money that they need back after they pay for you to be in the nursing home. So what happens is you apply for Medicaid. You might know that as Title 19. Let's say you're eligible and you're in a nursing home, for example, and the Medicaid program is paying for your nursing home care. And they do that for, could be a couple of years, could be 3 years, 4 years even. So typically we figure that you'll be in the nursing home for 2.5 years. So estate recovery would come to your estate after you pass away at the end of that, let's say 2.5 years. And they will ask your surviving spouse or your family, your loved ones, to repay the amount that they've spent on your behalf. So what that means is anything that you own at your death is recovered by the state. This program is required by the federal government. They have rules in place within the Medicaid regulations that say you have to recover when you pay out from the Medicaid program. And the reason that rule exists from the federal government's perspective is they want to make sure when a state is receiving federal money to boost or supplement their Medicaid program, that the states are being wise or they're taking care of that money well and using it well. And so the federal government says, we'll give you this money for Medicaid, but each state, you have to have this estate recovery program. Iowa, in their estate recovery program, well, they're actually pretty notorious, especially lately, being aggressive, you might say. There was a story published on NPR. One of the statistics in that story said that the state of Hawaii, which is about half as large population-wise as the state of Iowa, recovered $31,000 through their estate recovery program in 2019. And Iowa, in that same year, recovered $26 million. So that's 800 times more. And so you can see Iowa's got this pretty aggressive, advanced, intentional estate recovery program. And so they're going to come after people who are on Medicaid at any point during their life for their long-term care bills. And they're going to say, you have to pay us back for all the money we paid for you to be in the nursing home. But they can't just recover from everything that's involved in your assets. They can only recover from things that are included in your estate as it is defined by the Iowa Code. The Iowa Code uses a definition of estate that we call expanded estate in Iowa. The estate in Iowa is not just the probate estate. Some states will only allow recovery from assets that pass through probate. That is not Iowa. Expanded estate includes things in trust, meaning if you have a trust that you are a beneficiary of, those assets in the trust may be considered available for the purposes of estate recovery. So if we want to just walk through the definition, it looks a little bit like this. Iowa's estate recovery program can recover from all real property, meaning your house or other land kinds of assets, personal property, so your stuff, it's going to be cash, could be bank accounts, could be investments, could just be furniture or collections or things that you own. Any other asset, so fortunately for everyone, they've sort of said if it's not real property or personal property, but it's an asset, we get that too. Jointly held property, so if you own an asset with someone else, maybe it's a spouse, but maybe it's a child or a sibling. If you own it jointly, they will be able to recover against your interest. And then the last two things that they add beyond just those items are things like retained life estates, and I'll talk about what that is in just a second, and interests in trusts. So if you are a beneficiary or have an interest in a trust that's been set up for your benefit, that trust will likely be recoverable by the state. So what's a retained life estate? Well, a retained life estate is what happens when you take your house and you say, I want to give my house to my kids now while I'm still living, but I don't want to just give it to them because I still need a place to live. And so I'm going to retain the right to use the right to basically do whatever I want with my house while I'm alive. And when I die, my life estate ends automatically. We think of sometimes a property ownership, like a residence, as being a little bit like a bundle of sticks. And you have all these different rights that are part of that bundle. Things like the ability to use it, to live there, to access it, to keep people out, the ability to benefit from it, meaning you can rent it out and get the income off of that. All of these things that you think of that you can do with your property, those are things in your bundle. And if we were to take your bundle and we were to break it into two parts, we might break it into a part that is based on the present, today, and a part that is based on the future, or tomorrow. And we define when that present interest ends and what's the beginning of the future interest by saying with a life estate, that division happens at my death. So when I pass away, if I have a life estate and my children own what's called the remainder interest, then they own the property already, but their interest doesn't start until my death, until the future after my passing. So life estates that you keep for yourself are included in your estate for estate recovery purposes, which means basically anything that you own or could get a benefit from, the state's going to try to get to at your death. They do that by sending your family a notice. It's an estate recovery notice. It's going to say a couple of things right at the very top. The first thing it says is, you owe us however much money, $100,000, $200,000, $300,000. And the next thing it says is, we're sorry for your loss. So they tell you how much you owe, and then they tell you that we're sorry that your loved one has passed away. The people who are subject to estate recovery, that's the next thing we want to kind of highlight, because not everyone will be subject. Obviously, if you've never been on Medicaid, you don't owe the state any money, right? You're not going to have to pay them back for anything, and so you wouldn't be subject to an estate recovery claim. But if you did receive Medicaid benefits, and if you were over the age of 55, it covers any Medicaid benefits, not just long-term care. So any Medicaid assistance that you receive from the state after the age of 55 adds to your estate recovery obligation. For someone who's under the age of 55, the only time that you'll have coverage, so to speak, under Medicaid that will apply, that will be added to your estate recovery bill, is for long-term care in a nursing facility. They use a description called an intermediate care facility for persons with an intellectual disability, or potentially a mental health institute, if you went into that facility at the time could not have been expected to be discharged and return home. So someone who's severely disabled, has a degenerative disease or a neurological condition or things like that, that could not possibly return home after going to one of those facilities, they're going to be considered also part of that estate recovery program. So estate recovery comes after everything you've got, and they will expect that your loved ones are going to cash out whatever is there and pay them back. And now you might be thinking, well, I thought that I could have my house and still be on Medicaid. I thought that I could prepay for my funeral and still be on Medicaid. You know, I read that on the internet, or I heard that maybe the nursing home told you that, or the doctor or the discharge person at the hospital said that about your parent or your spouse. And that is true. You absolutely can hang on to those assets and have those things without being penalized for Medicaid eligibility purposes. But that doesn't change the fact that when you pass away, you no longer need those things, right? You don't need a home to live in. You don't need your funeral plan anymore because you've used it. So to the extent there's money left in your funeral contract, or to the extent that there's value in your home, maybe there's equity there because you don't have a mortgage or something like that, the state's still going to say, well, now that you're deceased, those assets aren't exempt anymore. And so because you're over the age of 55, or maybe you are under the age of 55, but we're in a nursing home, we're still going to ask your family to pay us back. Now, the last thing to talk about is there's a couple of, they call them waivers. We actually think of them more as deferrals because they don't waive the collection of the debt. They don't say, we'll never collect this money. They just say, we're going to wait. We'll wait and see, and we'll come back and collect from you or your loved ones at a later date. The first waiver is for a surviving spouse. So if you're married and your spouse is in a long-term care facility on Medicaid, your house is exempt. You can continue to live there. And when your spouse passes away someday, the state will still send you that notice, but they'll ask you on the notice form to tell them if you're married. And if you are, they will wait until your death to collect. But they're still going to come back to you and ask you for the money that the state has paid out on your spouse's behalf. And at that point, they may also ask for money that they paid on your behalf. In addition, a dependent who's under the age of 21, so someone who is reliant on you for support, they would also be an exempt person in terms of this waiver. So if you have a child who's dependent on you and you go to a nursing home and accrue this estate recovery bill, they'll defer collection of that debt until your dependent child passes away. There's also another waiver called an undue hardship waiver, which is provided in the event that collecting from your estate and pursuing that collection from your loved ones it presents some kind of a serious burden or some kind of major issue for your loved ones. Again, spouse probably falls under the surviving spouse waiver, but you might have a child who just really needs the money. On occasion, those undue hardship waivers will be granted as well. The NPR story I mentioned earlier talked about that a little bit, and they indicated that of 3,900 estate recovery claims that were made in, I believe, 2019, 40 of them were granted waivers under the undue hardship. So it's pretty difficult to convince the state that you fall under that exception just because the rules are pretty strict about that. So estate recovery is a very real thing. It comes back at the end. We sometimes think about it as a second bite at the apple because, in our firm, we help people get eligible for Medicaid. And then we also have to think about how do we protect assets if we're going to do that from that estate recovery claim. Because, for example, your family farm or your family business, those are things that you've worked hard your whole life to build. And so it might be really important to you to make sure that that passes to your kids, and estate recovery can be a really significant obstacle to that. So estate recovery, it's a real problem for people who are trying to pass down their legacy and their financial benefits that they want to leave for their family. But you can do things about it, and we'll talk about that, I'm sure, in a future episode. So don't forget about estate recovery when you're looking at Medicaid. Don't forget to ask questions through our website at KSOU, and we will see you next week. I always feel like it goes without saying, but please, please, please do not take legal action on your own because you heard it on this program. If you want to dig deeper on something you heard today, the Huizenga Law team would be happy to schedule a one-on-one vision meeting at our office in Orange City, where we can talk about your unique goals for your legacy. Just give us a call at 712-737-3885. You can learn more about elder law and estate planning issues on our website by visiting SiouxlandSeniorPlanning.com. And remember, it's not too late to protect everything you or your loved ones have worked so hard to build.